All set, Your Honor. It was a little slow this morning.
Okay, yeah, happy it's working. All right, welcome to the Appellate Court morning arguments, Tuesday, April 6th. The Appellate Court for the State of Connecticut is now out of recess and back in session. The appeal that we're hearing is Schofield v. Schofield, Todd Schofield v. James Schofield. I would ask that the judges participating in this hearing introduce themselves, then the appellant, and then counsel for the appellate. I am Judge Alvord.
I'm Judge Prescott.
Sorry.
I'm Judge Flynn.
Mr. Schofield, you have to unmute. There you go. Would you want to introduce yourself, Mr. Schofield?
Yeah, I'm Todd Schofield. I'm the appellant in this case.
Good morning, Your Honors. Joseph De Silva. I'm counsel for the appellee, Jane Schofield, the law firm DePantelis and Valerie. Thank you.
Okay. Thank you very much. The attorney De Silva and Mr. Schofield, you received procedural instructions for this hearing. Do you have any questions?
No.
No, Your Honor.
Okay. Typically, we do try and mute our mics when we're not speaking. And if by chance you get knocked off of the platform, no worries. We will not continue anything, and just reboot yourself in, and that does typically work. This hearing is being live streamed. So as a reminder, we are always careful with respect to any information that should not be disclosed via statute or regulation, and we don't disclose it while speaking. So keep that in mind. We will keep that in mind. I'm not so sure anything here it falls into that basket, but if it does, we will be careful. Each side has 20 minutes. Mr. Schofield, since you're the appellant, you can reduce a portion of your 20 minutes for rebuttal time. Just let me know, and I'll be setting the timer if you'd like to do that, and you can introduce yourself. We're all set.
The end.
Mr. Schofield?
Yes.
Okay.
Would you like to go?
Would you like to reserve some rebuttal time?
Just 2 minutes.
2 minutes. Okay. All right, we're ready to go.
Okay, I prepared an argument ahead of time, and let me just get right to it. Okay, this appeal is about the trial court's complete failure to follow Connecticut law governing the administration of a motion to dismiss. The trial court dismissed the plaintiff's sworn complaints as set out in his October 11th, 2019 memorandum of decision without ever applying or even referencing the Connecticut jurisprudence for administering a motion to dismiss as set out by the Connecticut Supreme Court in numerous cases, including Convoy versus State at 292 Connecticut 642 that was decided in 2009. Under Convoy, the trial court may look only at the allegations made in the plaintiff's sworn complaints where there were no disputing affidavits filed by defendant nor any conflicting factual evidence received by the trial court because the defendant failed to request an evidentiary hearing before the trial court. To establish the trial court's jurisdiction under Section 45A 187A of the Connecticut General Statutes for a de novo appeal of all the probate court orders to the trial court, the plaintiff correctly alleged in the sworn complaints that no proper notices were given by the probate court, nor any evidentiary hearings occurred as to all the probate court orders appealed. None of the plaintiff's sworn complaints, allegations on any claim or count were controverted by an affidavit by defendant, nor was any evidentiary hearing requested by defendant or held by the trial court at which any controverting against the alleged complaints could the only factual evidence in the record for the appellate court to is the factual evidence in plaintiff's sworn. Further, as specifically alleged in plaintiff's sworn complaints, no evidentiary hearing occurred on either January 29th, 2013. No witnesses were called, no witnesses were sworn in, and no record of submissions for an evidentiary hearing were maintained by the probate court, all as required for a probate court evidentiary hearing. There are no affidavits by defendant or defendant's attorney, timely requests by defendant for an evidentiary hearing before approving up notices or evidentiary hearings by probate court, because such affidavits or testimony would have been perjury. As such, plaintiff has irrevocably established jurisdiction of the trial court to hear the appeal of the various probate court orders under Section 45A, 187A of the Connecticut General Statutes. Also, the plaintiff, independent of a de novo appeal from probate court's orders under Section 45A, 186 or Section 180A, has the right to file a complaint to challenge the probate court orders in equity or lack of subject matter jurisdiction of the probate court and for the unequitable fiduciary breaching and fraudulent actions of the defendant, executor, fiduciary, and her attorney. The underlying probate proceedings are about the unlawful lack of respect by a self-dealing executor fiduciary, a corrupt attorney, and a novice probate. The requirements of the Connecticut probate court rules of procedure to protect and safeguard the rights of the family, members, heirs, and specific devisees. Essentially, the executor defendant, while a fiduciary of the decedent, sought to purchase from a mentally incompetent decedent the decedent's home at 546 Riverdale Drive for $400,000 and make the decedent thereafter pay the executor defendant $4,000 monthly in rent in September 2017. Second, without any discussion, defendant executor, while a fiduciary of plaintiff, sought to unlawfully evict plaintiff, while a family member devisee from 546 Riverdale Drive in September 2000. When that failed, she unlawfully claimed rent for 546 Riverdale from plaintiff, while he was a specific devisee and family member, and finally to fraudulently claim that the expenses of 546 Riverdale were expenses of the estate to gain control over the specifically devised property and to steal that property to herself at a below market value. Further self-dealing, the executor defendant currently occupies 546 Riverdale without paying any rent to either the estate or to other specific devisees. Under Connecticut law, the plaintiff has a right to challenge the orders of the probate court in equity that are beyond the authority or jurisdiction of the probate court, and due to the fraudulent actions of defendant, executor, fiduciary brought before laches occurred. As specified by the Connecticut Supreme Court in Bender versus Bender at 292 Connecticut 696 and Durham versus Durham at 204 Connecticut 303, a court in an equitable proceeding may provide a remedy even though the time limits for de novo appeals of probate court orders under Section 45A 187 or Section 45A 186 has passed. The plaintiff's sworn complaints initiated an equitable proceeding on first, the probate court's limited authority or lack of subject matter jurisdiction for its orders, and second, on the fraudulent self-dealing actions of the executor fiduciary defendant. No affidavits, the plaintiff's factual allegations, and no evidentiary hearing was requested to offer evidence to facts of plaintiff's sworn complaints. the Connecticut Supreme Court's prior rulings on administering motions to dismiss, including Convoy versus State of Connecticut 642, required that this appellate court reverse the trial court's order. The plaintiff's right to bring its claims was properly pled, and there were no affidavits offered by executor defendant, nor a request for an evidentiary hearing in which controverting evidence, the plaintiff's factual allegations, and his sworn complaint could have been offered. The plaintiff's equitable claims and subject matter jurisdiction claims are within the jurisdiction of the trial court, as established by the jurisdictional factual allegations of the sworn complaints. The defendant executor was obliged to dispute those jurisdictional facts by either affidavits or requesting an evidentiary hearing and introducing controverting evidence.
Mr. Schofield,
Defendant failed in its
Mr.
obligation to
Schofield,
dispute.
Mr. Schofield, I
Yes.
just have a small question. On page 7 of its memorandum of decision, the trial court says, based upon the record before the court, the plaintiff attended and participated in every hearing before the probate court. Do you dispute that sentence?
That I was participating in status meetings at the probate court, but no one was sworn in, right? No evidence was introduced. And the probate court ruled on facts that are outside of the.
So you were there in what you categorize as status hearings, and what the probate court, what the trial court state uses the noun hearing. You were there. You're just saying when you spoke, you weren't under oath.
Yes, I was.
You weren't
That's
put under
correct.
oath.
No one was put under oath, and there's nothing in the probate court record.
Was
that
there a need?
introduced.
Was there a need for you to be under oath?
Well, that was the purpose of having a proceeding. We weren't even notified what the proceedings were about. And Attorney
Okay.
Knott never put it, the papers that the probate court judge utilized, right, were never provided to us.
And just want to, who's the us? It's you and who else?
Well, my brother's a party also.
Oh, he was at the hearings also?
Yes,
So both you and your brother were at the probate hearings?
yes.
Got it. Thank you.
Well, we were at the status.
Thanks. Got it.
All right. The plan equitable claims in subject matter jurisdiction claims are within the jurisdiction of the trial court. The statute of jurisdiction is obliged to dispute those jurisdictional facts by either affidavits or requesting a request. They were needed to provide evidence that were part of these status meetings. As mentioned before, no one was sworn in, and so meetings weren't. The trial court was confused somehow that the false arguments of an attorney to somehow evidence when in fact they had no evidentiary value. The only evidence in the record before the trial court or this appellate court were the sworn complaints of the plaintiff, which factually is trial court jurisdiction for both the de novo appeal under section 45A 187 and for claims under equity. The probate court is a court of restricted and limited jurisdiction. The appellate court is obliged to void the orders of the probate court where a lack of authority or subject matter jurisdiction is demonstrated. The probate court, December 4th, 2018, pro hoc advice to require a party to a probate proceeding to qualify as an out-of-state attorney. The probate court's February 5th, 2019 rent order is void because the probate court has no authority or jurisdiction as specified in Section 45A 321B or Section 45A 421A to require plaintiff, a family member, or a specific devisee to pay rent. The probate court's February 15th, 2015, February 15th, 2019 sale order is void because the probate court has no authority or jurisdiction over specifically devised property that is insolvent, or where Section 45A 266 makes the liability of the specifically devised property the sole responsibility of the specific devisees, not the estate. The probate court's April 23rd, 2019 eviction order is void because the probate court has no authority or jurisdiction over eviction, which is restricted to housing court. Defense citing the Connecticut Supreme Court's Conservancy LLC versus the London at 265 Connecticut 423.
Presentation.
Excuse me?
I was unable to hear the last 2 or 3 minutes of your presentation, and I want to because I was unable to hear it because it was chopped up. Can you repeat what you just said for the last 2 or 3 sentences so I'm able to hear it? There was some chop in the,
Okay.
in the body.
I'll start at the beginning of the paragraph I was reading.
But before you
The
do
probate
that,
court,
Mr. Schofield, before you do that, your Wi-Fi connection isn't the greatest. Can you move closer to your Wi-Fi router or do something to improve the connection that you have?
all right. Let's see where. Okay, so the probate court is a court of restricted limited jurisdiction. The appellate court is obliged to void the orders of the probate court where a lack of authority or subject matter jurisdiction is demonstrated. The probate court's December 4th
Judge Albert, how much time did he have left? How
4
much?
minutes. So, and I was also thinking we could always ask for that submission that's been written out that he's reading from to supplement any issues. So let's just wait to see if he boots himself back in here.
Attorney De Silva, do you have his phone number?
Yeah, Your Honor, I don't believe I have a current phone number for him. I was only appellate counsel. I wasn't counsel below. I'm not sure if I have it. I will look, however.
Understood.
Your Honor, do you want me to contact Sean? IT? It's
Yeah,
Laura.
I'm wondering why they left. Did
All
they
right.
typically leave?
Yeah, I usually when everything's almost seems to be going okay.
Okay.
So give me a moment.
I have a phone number in the email, Your Honors, for Mr. Schofield. I will try it and see if it works.
Yep, I do see that Gmail, but he's on his son's computer. We do have a phone number in here, which maybe very well be a cell phone. So I'm
Your Honor, I was able to reach Mr. Schofield on the cell phone number that was in his email signature block. He's trying to log back in.
Okay.
I told him not to panic and that that everybody was waiting for him.
Thank you.
I think I made it back here.
Okay. Mr. Schofield, I paused the timer at 4 minutes, and we're also happy to accept your the written materials that you're reading from, in addition to your brief, if you want to submit those after the hearing.
Certainly.
Okay, so if you just wanted to continue back where you were when you moved into the different room, that would be great. Or
Okay. So I'll just start with that paragraph again. The probate court is a court of restricted and limited jurisdiction. The appellate court is obliged to void the orders of the probate court where a lack of authority or subject matter jurisdiction is demonstrated. The probate court September 4th, 2018 Pro Hoc Vice order is void because the probate court has no authority or jurisdiction to require a party to a probate proceeding to qualify as an out-of-state attorney. The probate court's February 5th, 2019 rent order is void because the probate court has no authority or jurisdiction as specified in both Section 45A 321B or Section 45A 421A to require plaintiff, a family member, or specific devisee to pay rent. The probate court's February 15th, 2019 sale order is void because the probate court has no authority or jurisdiction over specifically devised property that is insolvent or where Section 45A 266 makes the liabilities of specifically devised property the sole responsibility of the specific devisees, not the estate. The probate court's April 23rd, 2019 eviction order is void because the probate court has no authority or jurisdiction over eviction, which is restricted to housing court. Defendant's counsel, citing the Connecticut Supreme Court's decision in Fort Trumbull Conservancy LLC versus New London at 265 Connecticut 423 from 2003, the lack of a probate court's subject matter jurisdiction or authority when discovered must be addressed when it is raised in either a Section 45A 186 or Section 45A 187, de novo appeal, or in an equity-based complaint. The lack of probate court authority or subject matter jurisdiction to render any of the orders cited makes those orders void, which this appellate court is obliged to decide.
You have 2
Also,
minutes,
the probate-
Mr. Schofield, to summarize your argument there. And you have 2 minutes rebuttal after Attorney De Silva speaks.
You muted yourself, sir.
So as a final statement, as established by the Connecticut Supreme Court in Convoy versus State, the only factual evidence before this appellate court to make its de novo decision on the motion to dismiss are the sworn complaints of the plaintiff. There are no other facts in the record on which to base a motion to dismiss, since the defendant filed no affidavits nor timely requested an evidentiary hearing before the trial court to controvert the facts set out in plaintiff's sworn statements. Further, those sworn complaints clearly established this appellate court's obligation to void all the cited probate court orders for being beyond the limited authority or subject matter jurisdiction of the probate court.
Oh,
Thank you
Okay.
for your time.
okay, you still have your remaining 2 minutes for rebuttal, Mr. Schofield, okay?
Thank you.
All right, Attorney De Silva.
Good morning, Your Honors. I will try to keep this brief and focused. There was lots of colloquy during the presentation of the appellant regarding whether probate court orders were void or not void, the jurisdiction of the probate court. None of that is actually before this court today. The only thing at issue before this court today is Judge Welch's decision to grant the motion to dismiss and dismiss the appeal from probate. Now,
Attorney De Silva,
yes, Your Honor.
can I ask you this? What was there in the record before the Superior Court regarding Mr. Schofield's attendance at the various hearings that are the subject of the appeals?
Well, initially, I would note a reference to what Her Honor indicated earlier, Judge Welch's reference in his memorandum decision. That references back specifically to the argument before the trial court, the transcript of which is I refer to page A430 of the appellant's appendix, where Judge Welch inquires as to whether there's any disagreement from Mr. Schofield about his attendance at the various hearings. And much as his answer was today, he did not disagree that he was in attendance. He disagrees that they were hearings. Similarly, while, and I reference now starting at page A24 of the appendix, the appellant's complaint appeal from probate that was filed with the Superior Court. To be clear, it is not a sworn complaint. We have a process to swear complaints, verified complaints. This is not that. There is no attestation under oath on this complaint. That said, it is certainly judicial admissions. The plaintiff's complaint includes a series of attachments and exhibits that are incorporated by reference. Those exhibits are notices from the probate court, decisions of the probate court. By way of example, I cite it begins at page A56 of the appellant's appendix, which is the probate court's February 15, 2019 decision that Mr. Schofield spent a few minutes discussing. That references not only does that reference all of the details one would expect a memorandum decision emanating from a hearing to reference, it also references specifically on page A57 of the appendix the heirs, Tyler and Todd Schofield, who vocally objected to this purchase and the opportunity to hire and procure an appraisal of the property to refute the fiduciary and her other brother's appraisals. In other words, Mr. Schofield participated in the hearing. He presented evidence at the hearing, and the probate judge goes on. Instead, the objecting parties offered up a comparative market analysis created by a realtor from Higgins Group. Not only did Mr. Schofield attend that hearing, he participated in that hearing, vocally objecting and presenting evidence. The fact that it was not persuasive evidence does not make it not a hearing. Similarly, in an earlier matter, Mr. Schofield also referred to the December 4th, 2018 memorandum of decision by Judge Alberg in the probate court. Judge Alberg references that they held a tedious hearing on this issue, on the issues of a motion to re-argue. In terms of notice, by way of example, I point to page 889 of the appendices, of the appellant's appendix, which is a notice of hearing on probate court form PC 130, advising that on January 29th there was going to be a hearing. It specifically says a hearing has been scheduled on the above petition. That was sent out along with an order of notice of hearing, which appears on page A90 of the appellant's appendices, indicating that there would be a hearing on January 29th. Because Mr. Schofield does not wish these hearings to be hearings, or because he takes issue with whether they were or were not hearings, does not make them not hearings. The probate court held hearings on all of these issues. There were hearings. There was evidence taken, or however the probate court conducted the hearing. The hearings were conducted. The rulings were issued. If Mr. Schofield wished to take issue with how those hearings were conducted, there was a process by which he could do that. That process involved properly filing an appeal under Connecticut General Statute 45A 186 and 187 within 30 days of the issuance of the decision. It is understood that the appellant rests upon the provisions of 45A 187 that allow an appeal within 12 months. That only applies in the limited situation where the party did not receive notice and was not present. Burnell versus Churchus, 173 Connecticut Appellate 788 at page 795 makes it very clear that that first component of 45A 187 is to be read in the conjunctive and matters. It is not just did not receive notice, it's did not receive notice and was not present. There is no question here that Mr. Schofield was present at all of these proceedings. He just wishes them not to have been proceedings. There's no law to support that contention. And that matters because that governs and that controls the trial court's decision, and I believe this court's decision, related to counts 1 through 8, 10, and 11, all of which were appealed in an untimely manner beyond the 30 days. Count 9, which Mr. Schofield did not direct particularly directly, concerns an appeal of the probate court's failure to take an action, failure to decide a motion. As Judge Welch decided and found, can't appeal an order of a court that was not made. An action not taken cannot be appealed. It's not right. It's not justiciable, as we set forth in our brief. Finally, in relation to the last count, count 12, which relates to the appeal relevant to the summary process orders, the probate court in this case did not evict Mr. Schofield. The probate court authorized the executrix to go forward and commence an eviction process. There was an appeal of that order. Judge Welch found that appeal to be moot based on Mr. Schofield's stipulated judgment entered in the summary process action. That it effectively had been rendered moot. There's no relief that could be granted based on this appeal, based on his concession of jurisdiction of the housing court and his agreement to judgment. The fact that Judge Welch was correct is amply supported by the fact that that summary process case went to judgment, carried forth through judgment, carried forth through an appeal that was dismissed after stay was terminated and review was denied, and Mr. Schofield was removed from the property. I'd ask the court to take judicial notice. It's appellate court docket number 43638. Mr. Schofield was removed from possession, and that appeal was dismissed by this court as moot, because once a tenant in a summary process action has been removed from possession, there is no longer any relief that may be granted by the continuation of the appeal. So if the summary process appeal was moot, appealing from the probate court order that permitted that to go forward must therefore also be moot. Not only was it moot at the time Judge Welch issued his orders, it can't be more moot today, but if that concept were real, we would argue that it is more moot today. And that really is the very simple matter of this case. It is to get into the merits of what the probate court did. There was a process. Mr. Schofield did not follow that process. appeals of probate court matters are jurisdictional. The appeal of the probate of a probate court order is jurisdictional, as set forth in the case law, as we recite in our brief. Once that appeal period has run, there is no appeal, there is no subject matter jurisdiction in the court to entertain that appeal. Thus, the reason why Judge Welch dismissed the case, and thus the reason why we believe Judge Welch must be upheld. I have nothing further unless your honors have any questions. Or feel I didn't address something.
Don't believe we have questions, Attorney De Silva. So, Mr. Schofield, you do have your 2 minutes rebuttal time.
Thank you, Your Honor. Yeah, just like to make a couple of points. Is the same thing that's happened in the probate court and in the Superior Court, and now here in this hearing is we have had attorneys testifying, but no evidence was put in place. Attorneys arguing, about topics when Attorney De Silva was not at any probate court meeting and he wasn't at any Superior Court events. So him arguing about what happened in those cases, he wasn't even there. Going back to the only evidence that's in the record is the sworn statements and submissions that we put in place. That's it. The attorneys had the opportunity to either have an evidentiary hearing or to put in their own sworn statements. That never happened. All right. So arguing about events that you weren't a participant in just doesn't, fit the bounds of proof or evidence. Thank you.
Okay. Thank you. Mr. Schofield, if you would like to submit the written out argument that you presented in your primary portion of this hearing, you can contact your case manager at the in the clerk's office.
Right.
Okay, and we will be sure and give our clerk will give her a heads up, or him or her, I don't know who your case manager is, the heads up that you'll be contacting them, and we would just to supplement our notes of what you said and to supplement any potential issues with the recorded hearing. Okay, so we'll give you.
Okay. Yeah.
Are you thinking you'd want to do that?
Yes.
Okay, so we will give you, this is Tuesday, so why don't we give you 48 hours to get that over to our clerk's office, okay?
Okay. That sounds great.
And be sure that you also send a copy of it, just for purposes of fair play and all, to Attorney De Silva. Okay, just scan that would be good. Okay, anything further, judges, my colleagues, any issue with that? No? Okay. All right, thank you both. This hearing is concluded.
Thank you, Your Honor.
Thanks.